Hello, everybody. I'm here. I'm still doing stuff in the background. Bear with me. We'll be getting started very soon. Just bear with me. Everybody keep talking amongst yourselves. Yay, 20K. All right, unless I miss my guest, the next song is the intro song. When we hear the intro, we know what that means. By the way, Miss Thang, big thank you. That is really freaking cool. I really appreciate that.
Like everything and nothing.
Oh my. That's the end of the intro song. The theme song. It's Rural Thief. I can't even say it right. Yin Yang Stories. Amazing song. I have access to it through Epidemic Sounds. Love the service. Hello, everybody. 20K. Yay. Right? I'm here. I'm going to be silly. We're going to have fun. I have videos. They are videos I have not published previously. They are from the cutting room floor, so to speak. The docket that we're going to see second in line is actually from yesterday. I think the little Simpson clip may be from yesterday too. We're going to start off with a set of Simpsons. I think the second hearing in the Simpson may have been making the rounds today, but hey, I saved it for this. And then the second set that we're going to see is going to be some Kansas with Regier. Actually, it's with oh gosh, I can't remember his name. Canfield? The guy that looks like Regier. Regier's clone. It's Regier's clone and Regier in a set. And then we're going to go over to Texas to Judge Stevens because I just like Judge Stevens so much. But for the time being, again, thank you for everybody who's showing up. Thank you for everybody who has subscribed to the channel in the last few months up till now. I can't believe we're at 20K. I honestly don't think I would have ever made it to 3K. I thought the channel would probably hit 3K and just plateau. But here we are. And you know what? We're not going to stop. If it keeps growing, it keeps growing. 20K to wherever. So, hey guys, we're going to watch some videos and maybe get attacked by a cat at some point in time. So, thank you for everybody for showing up. And let me see if I can figure out how to work this stuff here. Oh, hey, that happened. And hey, that worked. And
Good afternoon, Your Honor. Ellis Friedman for the plaintiff.
Your name, sir?
Robert Williams.
All right. And where are we on this?
He put his escrow in, and he's proposed he's actually proposed a consent order for dismissal where he would pay the balance, including February, by the end of the month, or the judgment and writ would issue. He hand wrote it out, and there's no signature page or anything. So I thought I'd put the terms on the record, and then if you let me file it, I'll file it.
Okay, very good.
So the terms. Oh, you got it. Okay. All right. Well,
Oh, he's got the.
maybe we can get this done. The terms are that the escrow would be released to the plaintiff.
Okay.
That he would pay $2,225 in rent, court costs of $205, $32 and other money due, total of $24.62 by the end of this month, plus the escrow being released.
So the only thing I need clarification on, the escrow comes off of that figure?
No,
Okay. After the escrow, gotcha.
yeah, this 24 number is after escrow.
Got it. Sir, is that a correct statement of the agreement you drafted?
Yes.
All right. You don't have any questions about anything that you drafted, do you?
I just want to get this over with, Your Honor.
Me too. All right. All right. Once everybody signs off on that, then I'll mark this as conditionally dismissed and I'll sign off on the order.
Thank you, Your Honor.
Thank you.
Do we need to do 4.201?
Yes, I would, even though it's his order. Sir, you have 3 business days to think about this. If you
Okay.
believe that there's some legal reason, some confusion, or some right you didn't assert, you would have to file a motion with the court within those 3 business days in order to set this aside.
Okay.
You understand that?
Be pretty tough since he drafted it.
Yeah, I mean, I'm like, never had to do it that way. What led you to do this? Let me ask you that, young man.
Well, personally, Your Honor, I feel like the money is owed, and
Pardon?
I feel like the money is owed, and I feel like while I'm waiting on Hawk, they tend to move slowly, and I want to get this over with as soon as possible.
What do you do? Are you a student?
No, well, I actually love law, but I work at the University of Michigan. Yeah.
Yeah. No, the reason I'm asking is because a lot of tenants aren't that proactive. And I think in all the time I've been doing this since really the conditional orders of dismissal have been, this is the first time that a tenant has come to me with this on the form. I mean, so I was just curious.
Oh.
I thought we might have a budding lawyer around. And I was gonna tell you, don't do it. All right. All right. Take care of yourself. Have a great weekend.
Thank you.
Barrington Barnes versus Sarah Johnson. Pardon? 16.
16.
Yep, 2 Fridays from today. Barrington Barnes versus Sarah Johnson.
Illustrate for the plaintiff.
Hello. What's your name?
Sarah Johnson.
Okay. And where are we on this one? She said she was moving by the 31st.
I've been moving, Your Honor, but I've been doing this all by myself. So I was intending to have keys back to them on Wednesday, which is the last day of my lease. That unfortunately did not happen. I was there all last night till like 2 o'clock this morning, moving stuff. I got back up this morning, called off work, and I've been there all day. I had a rather rude call from the apartment complex this morning, asking me about the keys, making threats to me, telling me she'd been in my apartment and asking if I had, intended to leave it in that condition. And I said, well, I didn't give you keys. I'm still in the process of moving out. You didn't have permission to come in my apartment. So like, she's now telling me she's gonna charge me another whole month's rent. And I literally left there with a load of stuff in my car to come here for this hearing. I don't even understand. I mean, I'm kind of like frustrated that they dragged me into court because they're the ones that said they weren't.
Well, ma'am,
I know I owe them. I applied for an SER and they denied me.
Okay, but
ma'am,
you had said that you were going to move by the 31st.
Yes.
Okay.
And I've been doing everything I can to do so. I'm down to like probably 2 carloads of things. I've been moving stuff with my car all week long. I tried to contact the attorney to be like, look, like I don't have time to be in court because I'm trying, I'm taking off of work to do this. I'm trying to get moved. And they just were like, go to court. Every time that I've communicated with them, they either don't respond to me or they, like just are rude.
You're not telling me my office is rude. I know that's not true.
I contacted them and I said, look, please don't make me have to go to court. Like I'm turning keys in at the end of my lease, like you guys asked to. And she just said, show up in court. And
here's what I'm gonna do. I'm not gonna, how much is owing through? Well, there was
Now it's
2737 through
3675, including 237 in cost.
how much?
Actually, 3675 plus 237 for 3912. That does include February. Because it is February.
Right, and it would be due and owing. I'm gonna find after hearing, but there's no.
The days that I have had the keys.
Did they leave? Yeah.
Yes.
Where's the judgment?
I have.
Did you sign it?
Yeah.
I need to look at it before you sign that thing. Stop them before we do that. I'm going to find no tribal issue. I'm going to grant judgment for possession to the plaintiff as well as a money judgment in the amount of 3912. Money judgment was requested. That's going to be retroactive back to the date where plaintiff forego did not ask for a judgment because you were moving by the 31st, so that's gonna take 5 days off of it. You're almost out of the premises, so a writ would issue the 5th or the 6th, excuse me, of February. Thank you.
Sir, I applied for an SER and they denied me, and I didn't even try to bring
They're
that
not
up.
going to, but sir, but ma'am, they're not going to pay if you're no longer in the unit.
At the time I applied, I was still there, and they told me that they would not take my, summons. That, I don't know why he told me that my summons was not an eviction, and that they denied me because the summons was. not-
Okay, but if they took it now, what do you think's gonna happen? SER is not gonna pay this amount.
I know, I understand that I owe them, but I'm trying to keep it down as much as I can, because I cannot afford to pay this.
Okay,
I mean, I can't afford to pay the whole February. I did not pay them December and January because I had to use that money to move, because they were
Okay.
supposed to renew my
and
lease.
here's what you do. I've given you to the 6th to get out of the premises.
I'm trying to have keys there today at
If
5.
you're gonna talk, then I'm not going
I'm
to.
sorry.
I've given you to the 6th to get out now that you haven't moved. What I'm going to suggest regarding the monetary portion is that you contact the landlord or Mr. Friedman and arrange a payment plan for that amount. That's the best way to handle this. Okay? SER, Hawk, anybody else, they're not gonna pay this. So you arrange a payment plan. I've given you a little bit more time to get yourself out of there, turn in the keys, and you're gonna be good.
So then am I gonna have to pay the whole month of February? If
I've included the amount of February in here. You can talk to them about that. February is due. Okay? That's the way it works. Thank you.
We enter into payment plans all the time.
That's right.
So is that also gonna show up on a judgment on my,
Ma'am, yes, it is. Don't wave me like that.
I'm trying to work with them and they were not willing to work with me. I called them, asked them to not cancel my lease, and they didn't even return my phone calls.
Okay,
Like, I
ma'am.
got bad landlord verifications from them, so I couldn't find a move to. Sorry. Like,
Ma'am, I understand the frustration. That's why you didn't get a judgment the last time you were here.
yeah.
I gave you to the 31st. You said you were gonna move. I realize the circumstance that you're in now, but I have to also be fair to the landlord.
I
And
know I'm gonna owe them the money, but every amount that you put on here is just putting me deeper into.
what do
debt.
you want me to do?
I would like to not have to pay the entire month of
Then talk,
February. I would like to have the keys turned in by 5:30 today, which I have enough time to do.
ma'am, if you turn in the keys, then you have a good argument to talk to them about not having to pay February. The problem is, right now, you still have possession of those premises. Your February rent became due yesterday.
And I have a 3-day grace to pay it, which is tomorrow.
Ma'am, I don't know what you're asking in terms of that.
Nothing. I'm sorry. I don't know what I'm asking. Thank you.
Thank you.
That was the symptom block. But yeah, hey, welcome everybody who's just now joining, and I'm gonna get it right back out there again. That light came on mysteriously by itself. It does that motion activated. It's supposed to. Just tells me that a certain somebody's back there. Anyway, 20K, yay! Hey, man, and all the super thanks. I do really appreciate the super thanks. Grayson, everybody I've seen that I can't remember. I'm going to scroll up real quick. Carolyn, I remember way earlier, Miss Thang. All y'all rock. I mean, I didn't even think I had the super thanks turned on. Yep, y'all are just surprising me. But hey, that's freaking awesome. Next set is the Canfield Regear Super Set. This one's a little long. I'm gonna go ahead and warn you. Get yourself a drink. Get you something to snack on. But there are a few cases back to back right here. I kind of skimmed through. I haven't watched all of them, but I've skimmed through them, and the ones that you see here are kind of curated from about a 3-hour docket call. I've chopped it down to about an hour. After this, we still have Stevens to go, and I think Stevens is a little over 30 minutes. So just so you know where we are time wise, everybody. I want everybody to be comfortable, and don't if you got something to do, thank you for coming by. If you're available to stay and want to stay and chat, we're going to be staying and chat. And unlike regular videos where I have Wolfie over here commenting, we are the comments. We're typing our stuff up. I'm posting it up there, and it'll be on the video when it's live on YouTube. So, hey, this is going to be the Canfield Regear Super Special set. Hope everybody enjoys it, and let's keep on doing the thing. Thank you, everybody, for getting me to 20K. I really do appreciate it. It's not something I ever expected to happen. It's a great milestone. I can't say thank you enough. All right, here we go. Canfield Regear, if I can figure out how to work my stuff. That easy.
Next matter, State of Kansas versus Faith Ellison, 23 TR 2447.
State appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Faith Ellison. Miss Ellison does appear from the Butler County Jail. Your Honor, this is one count of driving while suspended, Class B non-person misdemeanor. To that charge, Miss Ellison would enter a plea of guilty.
Is there any agreement concerning this? Any?
Judge, I think there's just what Mr. Canfield and I would term as a standard sentencing.
I just didn't know if there was another case that there was concessions being made in. So the defendant's pleading guilty to the sole count of driving while license is suspended, Class B misdemeanor.
Yes, sir.
Is that a first offense?
Yes, sir.
Very well. But Ms. Ellison, have you heard what the attorneys have told me?
6 yes, and then it's me and Patterson, and Mr. Patterson talked, and it was 6 months non-reporting with a 120-day suspended sentence, correct?
Well, you haven't been convicted yet, so you haven't been sentenced. Understand there may be recommendations by the attorneys in regards to what the sentence should be. The court has to follow at least the maximums that are allowed for that case. So for a B misdemeanor, the maximum punishment is up to 6 months in the county jail and a fine not to exceed $1,000. I'm not saying that's what the sentence would be. I'm saying that's just the maximum allowed. So while the court does listen to counsel and recommendations, ultimately that decision is mine in regards to what the sentence will be within the law. Is it still your wish to plead guilty to that offense?
Yes, Your Honor.
And you're waiving your right to a trial?
Yes.
Have you had ample time to discuss this with Mr. Patterson?
Yes, I have.
Are you under any coercion or forced in some way to enter this plea?
No, Your Honor.
And are you under the influence of any medication or intoxicants at this time?
No, Your Honor.
Very well. On or about May 17th of 2023, while you were in Butler County, Kansas, were you driving a motor vehicle upon a public roadway or highway when your privileges to drive were suspended or revoked?
Yes, Your Honor.
I do find there's a factual basis that the plea is knowingly and voluntarily entered and find the defendant guilty of first offense, driving while suspended. I will hear recommendations of sentence at this time, beginning with the state.
The state would recommend a fine of $100, 4 month or 120 days jail, suspended for 6 months of non-reporting probation, as well as any other cost or fees.
Mr. Patterson,
Your Honor, we'd ask the court to adopt the recommendations.
very well. Ms. Ellison, is there anything or statements that you'd personally like to make before I pronounce sentence?
No, thank you, Your Honor.
Very well. The mandatory minimum fine for this offense is $100, so I do impose that, as well as the court costs. In regards to a jail sentence, I will impose 120 days. I will place you on non-reporting probation for a period of 6 months. How long will it take you to get this case paid off?
I can have it paid off within a month.
All right, I will give you 60 days to have it all completely paid.
Okay,
Understand that the conditions of your probation, while it's non-reporting, is no violations of the law, and to get this obligation taken care of concerning your the costs and fine in this case. Please understand that if you don't get these things taken care of, it generally just multiplies on in regards to your driving privileges. Some people just don't take care of things and end up having suspended licenses for years and years. So it's good if you can get out of that cycle. Anything further on this case?
the 120 days is if I don't get if I mess up on probation, correct? Or if I
Right.
don't get my fines paid, okay. I just wanted to clarify that.
Right, and she will get credit for any jail time that's solely on this case. And if we are adjourned, she's free to go on this case unless she has a hold on another matter. Next matter is State of Kansas versus Rodney Hostetler, 23 TR 2369. Counsel state their appearances, please.
State appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Rodney Hostetler. Ms. Hostetler does appear from the Butler County Jail. Your Honor, in this case, I would announce that proof of insurance has been provided to the state. Based upon that, they have agreed to dismiss count 2. And at this time, I would announce Mr. Hostetler will enter a plea of guilty to count 1, no valid driver's license.
Yeah, I don't have a license.
And Mr. Canfield, is that correct? The state is dismissing count 2?
Yes, Your Honor.
Mr. Hostetler, is that correct? You're entering a plea of guilty to operating a motor vehicle when you did not have a valid license?
Yes, sir.
You understand, I believe that's unclassified misdemeanor, isn't it, counsel?
It should be a Class B, Your Honor.
B, okay. Do you understand that the maximum penalties for a Class B is up to 6 months in the county jail and a fine not to exceed $1,000?
I did not know that, sir.
All right. I'm not saying that's what the sentence will be. I'm just saying that's the maximums that the law allows. Do you want to reconsider that based upon that information?
No, sir. I'm just gonna get my license as soon as I get out of here.
Okay. Are you waiving your right to a trial with this?
Yes, sir. Is that right?
And has anybody forced or coerced you in some fashion to enter this plea?
No, I talked to my lawyer. My lawyer pretty much just whatever he says.
And by that, you mean you're following his advice as far as entering the plea?
Yes, sir.
All right. Are you under the influence of any medications or intoxicants at this time?
No, sir. I was supposed to go and start chemo, but I got arrested before then.
All right. On or about, looks like July the 10th of 2023, were you operating a motor vehicle on the Kansas roadways, public roadway, when you did not have a driver's license?
Yes, sir. But my wife did have a driver's license and she was in the passenger seat. She was trying to teach me how to drive.
Okay, you understand there's learning permits for that sort of thing.
Yes, sir.
I do find there's a factual basis and that the plea is knowingly and voluntarily given with the advice of good counsel. I find you guilty on count 1, operating a motor vehicle without a valid license. I'll hear recommendations for sentence at this time, beginning with Mr. Canfield.
State recommends a fine of $100, 120 days jail, suspended for 6 months, non-reporting probation, as well as any cost or fees.
What's that mean?
Mr. Patterson, any statements?
Your Honor, we just asked in addition to that, ask court to take up the issue of court-appointed attorney fees.
Very well. Mr. Hostetler, is there any personal statement you'd like to make at this time before I pronounce sentence?
No, sir. Sorry, I drove without a license.
All right. Well, it looks like you complicated matters for yourself by failing to appear a couple of times.
I failed to appear, but I did try. I guess I didn't know how to do the Zoom thing because it was a Zoom court, and I was the only one on the Zoom thing. So, I mean, it's my fault. But I did try. I didn't. It's not like I meant to miss. I just didn't know what to do.
Well, there were 2 times.
2 times.
Yeah.
I did not know that. So
November 29th, and then again, oh, no, I apologize. You were in court and they talked about your failed to appear on 11/29. So it was 1 occasion. All right.
yeah.
I'm going to impose a $50 fine. I'm not going to impose a jail sentence. I am going to impose $250 in attorney's fees. Mr. Hostetler, how long is that? And then there'll be $108 for court costs. So that looks like it's if I added right, $408. Mr. Hostetler, how long will that take you to get that taken care of?
Probably about 3 weeks to a month.
All right, I'm going to give you 60 days to pay it all.
Okay.
If it's not paid after 60 days, then it'll go to collections, and then also the clerk's office will send what they call a suspension letter to the state of Kansas. Even if you don't have a driver's license, they can create one for the sole purpose of suspending it. And you can really, it can really kind of compound itself. We see individuals that have sometimes dozens of those offenses, and they don't get it taken care of, and it just gets more expensive. And some people end up spending quite a little bit of time in jail over it. So I'd suggest that you not tempt fate with that on that. All right.
All right. Thank you, sir.
Okay. If you're being held solely on this, he can be released. Good luck with your treatment.
Thank you so much.
Court is adjourned on that matter. He's free to maybe released. Next matter is State of Kansas versus Robin Nicole Howerton, 22 CR 192. And are you Robin Howerton?
Yes, Your Honor.
Have counsel to state their appearances, please.
State appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Robin Howerton. Ms. Howerton does appear from the Butler County Jail. Your Honor, this is a warrant to show cause. I can tell the court I have discussed the warrant to show cause with Ms. Howerton. She would be waiving hearing, stipulating to violations, Your Honor. I would further tell the court that upon the court accepting her waiver, finding violations, there is an agreed recommendation to the court. That agreed recommendation would be to modify the sentence to 30 days have her serve that 30 days and then close the case. I think some of the reasoning behind this is that Ms. Howerton has some other serious matters that is going to pretty much control what she does with her life. That includes, I think, what Your Honor has before her on another case, a permanency hearing coming up. So she has got a full plate as it is, Judge. So I think we would ask the court to adopt recommendations when that time comes.
Mr. Canfield, I'm not sure, is there any agreement that, well, is that correct in regards to the recommended modifications?
It is, Your Honor.
And counsel, can you say that again as to what the parties are agreeing to?
To modify the sentence to 30 days, have her serve that full 30 days, and close the case. Your Honor, would just announce to the court, just for the court's information, she has now been in jail since January 12th on this case.
Did she have any other jail credits before then?
I don't have that information, Your Honor.
All right.
1 day, Your Honor.
All right. All right. Ms. Howerton, have you heard what the attorneys have told me?
Yes, Your Honor.
And is that correct? Well, first of all, you understand that with a warrant to show cause, or a motion to revoke probation, the state would have the burden of showing by a preponderance of the evidence, which is just more likely than not. That would be their burden of proof if this matter, but you are entitled to a hearing before the court to make that determination. Are you waiving that right?
Yes, Your Honor.
You understand while there's recommendations for sentence modification, the court is not required to do so. It looks like Judge Webster sentenced you to an underlying case of count of 6 months.
I believe it was Judge Murphin.
Okay, Judge Murphin. Now, it looks like the sentence was imposed November the 21st to 22. So you understand that while there's a recommendation to reduce your sentence, that the court's not required to do that.
Yes, Your Honor.
All right. Are you under the influence of any intoxicants or medications at this time?
No, Your Honor.
Has anybody forced or coerced you in some fashion to enter this plea?
No, Your Honor. Your Honor, and the only thing I would like to say is you do have me on a permanency hearing for my son. I have my youngest. My mother has cancer. I've been taking care of her. I do have other matters going on. That's just all I wanted to say.
All right. Mr. Canfield and Mr. Patterson, any additional comments in regards to recommendations?
No, Your Honor.
Oh, Your Honor.
All right. I do find that the defendant has admitted to violations by not reporting as directed, and she waives her right to a hearing on this matter with the advice of good counsel. All right, Ms. Howerton, how long is it going to take you to get this thing paid off?
My fine's already paid off, and I have it on my bank statement.
Okay, when did that occur?
That occurred the January after I got put on probation. It was a little over $400 that I paid online.
And Your Honor, I would note that CSO Ryan Smith is here, and perhaps he could provide a bit more information for the court.
Well, and I was looking at what was filed June 23rd June 9th of 23, so it may have been taken care of by this time. Be that as it may, I am ready to pronounce my ruling. I do find she has violated the terms of her probation and revoke the same. Pursuant to the negotiations, I am going to reduce her jail sentence to 30 days. She's not placed on probation from that. Any unpaid portions of this case, if any exists, will go to collections. And she will receive jail credit for any time that she served it on this case. I haven't added up those days, but it looks like you would have a little bit, probably seems more like than a little bit to you, but you should still have several days to serve. But once you've served your sentence, then this case will be closed.
Thank you, Your Honor.
Counsel, anything further?
No, Your Honor.
No, Your Honor.
Very well. This matter is adjourned. Next matter is State of Kansas versus Boyd Dean Love II. And are you Boyd Love II?
Yes, Your Honor.
If counsel would state their appearances, please.
State appears by Devin Canfield.
Your Honor, Darren Patterson appearing on behalf of Mr. Love. It does appear from courthouse security. Your Honor, in this case, I would tell the court that Mr. Love is going to waive hearing. There is one alleged violation. He does stipulate to that violation that he did consume alcohol and illegal drugs as stated within the affidavit.
Are there any agreements between the parties for this admission?
Your Honor, we have made some agreements in this case to recommend that he have a 48-hour sanction, that he be placed back on probation for 12 months with an order to get a drug and alcohol evaluation, and all prior orders of the court would remain in place.
Mr. Canfield, is that correct?
Your Honor, I would just add that the state is requesting a substance abuse disorder or substance abuse evaluation as well as a DV assessment, as there is a pending aggravated battery case with this defendant as well.
And that is, of course, not part of the PV, Judge, but I've talked to my client about both of those. He is not objecting and in fact would join in the recommendation of both of those, Your Honor.
All right, and it would appear that the sentence on March the 6th of 23 was on count 1, a 12-month underlying jail sentence, and count 2 was also 12-month. Is that correct?
Yes, Your Honor.
All right, Mr. Love, have you heard what the attorneys have told me?
Yes, Your Honor.
Do you understand? Well, first of all, you are entitled to a hearing on whether you violated your probation or not. The state would have the burden of proof by a preponderance of the evidence, which means more likely than not. If they couldn't meet that burden, then that charge or the motion would be dismissed. If they could, then the court could find that you violated the terms of your probation, which is basically What I'm being told is you're waiving your right to that hearing. Is that correct?
That's correct, Your Honor.
Have you had ample time to discuss this with your attorney?
Yes, Your Honor.
You understand that while there is a recommendation in regards to how I should treat this at this time, the court is not required to follow that. You could be ordered to serve your sentence as originally imposed.
Yes, Your Honor.
And with that in mind, is that still your wish to make this admission to the violation?
Yes, Your Honor.
Very well. Are you under the influence of any medications or intoxicants at this time?
No, Your Honor.
And has anybody forced or coerced you in some fashion to enter this plea or this admission?
No, Your Honor.
Very well. The court finds through stipulation of the defendant that he has violated the terms of his probation, that the defendant has waived his right to hearing on this matter with the advice of good counsel. Counsel, is there any other recommendations or statements that you wish to make before I announce my decision?
No, Your Honor.
I would just briefly state, Your Honor, I did talk to my client about this violation. He did tell me that he was at a very low point, that somebody offered him a pill. He took the pill, and which was something from the test results, was a little concerned about, but he did tell me that it was said to be ecstasy. I did some reading, and what I have found is that they are lacing ecstasy pills with methamphetamine, so you could test positive for both with just one pill. But he has admitted that to his probation officer, admits it here today, Your Honor, and we just ask the court to consider following the recommendations.
And Your Honor, I was informed that the defendant did sign an admission to using those substances as well.
Thank you. Mr. Love, is there any statements that you'd like to make before I announce my decision?
Yes, Your Honor. Your Honor, I was at a really low point in my life, and I made a mistake. Honestly, I'm gonna have to deal with that. And I understand that it was just a horrible idea, and I'm just looking to move forward with my life. I'm the primary breadwinner of my house, and I don't want to see my actions result in suffering for my entire family, including my kids. That's all.
I guess
Has the defendant ever completed the domestic violence assessment?
Not that I'm aware of, Judge, but he would probably know better than anybody. Have you done a domestic violence assessment before?
No, I've never taken one before. No.
Well, it looks like you were ordered to do that, or an anger management program. Did you take that?
He did complete the anger management, Your Honor.
Okay. Well, Mr. Love, I'm frankly a little bit concerned here, more than a little bit, actually. You were convicted March 6th of 23 of assault on a law enforcement officer, Class A misdemeanor, and interference with law enforcement, also Class A misdemeanor. Those are pretty serious offenses, and you were placed on probation for them. You talk about a low point in your life when you made one mistake. It looks to me like you've made a series of mistakes here. What's it going to take to change that?
Your Honor, I've been working towards strengthening my relationship with my higher power. I know I've made some mistakes in the past. Moving forward, I'm just trying to be the best individual that I can be and try to make amends for those however possible. I'm like I said before, I know I made some mistakes, and I'm trying to do my best now. And those mistakes are mistakes that can never happen again.
Well, what you've admitted to is the drug issue, taking those drugs. And that's the only thing I'm finding in violation of. I note that the motion had some other things that frankly were more serious, but you didn't admit to that, and there hasn't been a hearing on that. I am going to revoke your probation. I am going to order a 48-hour sanction to begin now. And I'm going to place you back on probation. I want you to get the the domestic violence assessment and follow those recommendations.
Absolutely, Your Honor. Thank you.
Well, I'm going to tell you something though. You come back before me on another violation, you probably better be thinking how many days, you got served and how many rest to serve 12 months.
I understand.
I'm seeing here some very real concerns in regards to violence towards others. And you're still a young enough person to get past those issues. And if you've learned something, but if it hasn't been motivation enough yet, trust me, I got no problem with you serving your whole year.
I understand, Your Honor.
Another thing that you might want to take into consideration, Mr. Patterson, in his statement in regards to various drugs such as ecstasy being laced with other drugs such as methamphetamine. Another thing that we're seeing sometimes in autopsies is that these pills and various other drugs are being laced with, fentanyl. So the idea of just taking something that somebody's handing you can be pretty darn dangerous these days.
I understand.
You will, the terms of your probation will include all of the ones that was originally imposed, other than what the ones that you've already satisfied. But you've run out of grace on this case. Can't put it any simpler than that.
I understand.
Very well, but he can be taken into custody and then released once he's served his 48-hour sanction. You are to report to your probation officer as soon thereafter. You need to contact them by phone, and they'll set up an appointment, and you need to make sure that you are in full compliance with the terms of your probation. You still being able to hear me?
Absolutely.
Very well.
And Your Honor, I did get that the court was ordering the DV assessment. Is the court also ordering the substance abuse evaluation as well?
Yes.
Thank you.
And you need to follow those recommendations. That may or may not, I'm not going to guess what those, but they need to be, the evaluations need to be a place that is approved by the probation office. I don't want some fly-by-night place that has the same recommendation, then charge $100 for nothing. So, very well.
And Your Honor,
Further in this case?
one last question, Your Honor. Was the probation reinstated 12 months beginning today?
Yes.
Thank you.
Mr. Patterson, anything further?
Judge, I thought Ms. McManus had a question, but maybe that was the answer.
Your Honor, that was the answer.
Okay, I have nothing further, Judge.
Mr. Love, good luck to you.
Thank you, Your Honor.
No, I can't remember.
Looks like we have,
Absolutely, yeah.
let's take State of Kansas versus Caden West, 23 TR 22898. Mr. Pate, do you need a breakout with your client, Mr. Howard?
Thanks, Judge. I already talked to him. We'll be ready to go when the court's ready for that case.
Okay, well,
Thank you.
Let's finish out, Mr. All right, is Mr. Caden West present?
Judge, he is in the Butler County Jail.
The council would state their appearances, please.
State appears by Devin Canfield.
Your Honor, Darren Patterson appearing on behalf of Caden West. Mr. West does appear from the Butler County Jail. Your Honor, in this case, at first appearance, Judge Satterfield did order a competency evaluation to be completed. We have received that report and are first of all ready to proceed on that issue.
Also, I would like to add that today I was issued with a failure to appear warrant out of Leon, Kansas. I was in custody at the time of the hearing.
One thing at a time, Mr. West, okay? We'll take this other matter up first.
Okay.
I note that the docket notes do reflect that competency evaluation order. I do not have a copy of that actual evaluation, though. The council, if council would advise me in their statements how they wish to proceed.
Your Honor, would tell the court that there has been a competency report or evaluation submitted by South Central Mental Health. That report is looking for the date. I don't see a date on it, but it was just a day ago, Your Honor, by Dr. Chelsea Gwynn. The findings of Ms. Gwynn is that he is competent to proceed on this case, and we would ask the court to find that he is competent to proceed. I would also tell the court, I spoke with him. I think he's fully competent to proceed also, Your Honor, in my opinion.
Very well. Very well. The court does find that based upon the evaluation and the assessment and Mr. Patterson's contact with his client, I do find that he's competent to proceed. We will proceed at this time. Looks like, well, counsel, are there any agreements in regards to this case at this time?
Your Honor, I would announce at this time that I have discussed the charge with Mr. West, that he would enter a plea of no contest to the charge of driving while suspended Class A non-person misdemeanor.
Is there any agreement between the parties?
Again, Your Honor, I think what would be considered is the standard recommendation that's entered into by agreement, state and defense.
And Mr. Canfield, is that your understanding as well?
It is, Your Honor.
All right, Mr. West, have you heard what Mr. Patterson has told me?
Yes, he gave me the rundown pretty much, the whole run through on Tuesday when we did. Wednesday when he had talked to me, and Tuesday when we did the competency exam.
Okay, well, And he advises me that you're going to plead no contest to driving while suspended, a Class A misdemeanor. Is that correct?
Yes.
You understand that with a plea of no contest, if the state presents what we refer to as a proffer, but basically a statement that what you did, if the court finds that sufficient, I would find you guilty.
Yeah.
Are you wishing to waive your right to a trial?
Well, my question is what would be the difference if you're gonna find me guilty already as is anyways? What would be the difference if I was to plead guilty? Because if I was to plead guilty, wouldn't you already like sentence me to fines or whatever? Or
Okay, well, basically, a no contest plea is a person saying, I'm not contesting, I'm not challenging what the state is, but I'm also not admitting to it. Sometimes people do that. One of the reasons sometimes that happens is because there may be a likelihood of a civil suit, so that, there's a plea of guilty, you're admitting the offense. As far as a practical matter, if the court finds that you are guilty, then you'd be sentenced like you had pled guilty, or a jury had found you guilty, or the court had found you guilty.
Okay.
It's just one of the ways of getting there, and basically, if a person's not wanting to do a trial, that's one of the pleas that the law allows.
Okay.
All right. And you understand that while there may be recommendations that the attorneys make, the court is not bound by those. The maximum punishment for a Class A misdemeanor is up to a year in the county jail and a fine not to exceed $2,500. I'm not saying that's what the sentence will be. It's just the maximum allowed by law. With a second offense, second or subsequent offense, driving while suspended, I believe there's a mandatory minimum of 5 days. However, probation can be granted. Additionally, there's a mandatory minimum fine of $100. That's true of a first offense as well. And counsel, if I misstated that, please correct me. I don't have the statute in front of me, and sometimes I need to do that.
Judge, that's all accurate from what I understand also.
All right. So, Mr. West, are you pleading no contest then?
Yes, I'm pleading no contest.
All right. And have you already indicated you'd had time to consult with Mr. Patterson? Do you understand that you'd be waiving your right to a trial with that plea?
Yes, I do.
Okay. And are you under the influence of any medications or intoxicants at this time?
Not intoxicants, but I am under the influence of medications, mental health medications.
All right. Do those make it easy, or is it cloud your judgment, or do you think it makes it easier for you to think clearly?
And sometimes it clouds my judgment, but not today, sir.
Okay, you feel like you're
I'm up to par today.
all right. Has anybody forced or coerced you in some fashion to do this?
No.
Plea? And Mr. Canfield, what would the state's evidence be if this matter were tried?
Thank you, Your Honor. Should this case proceed to trial, the state would show through testimony or other evidence that on or about June 18th of 2023, law enforcement stopped a 1999 GMC Jimmy.
That's what this is right here.
And the defendant, Mr. West, was driving that 99 Jimmy. It was discovered during that stop that the defendant's license was suspended. The defendant had previously received a notice from the state of Kansas that his license was suspended on February 9th of 2023. As this is a second driving while suspended, there is also one prior out of Wichita municipal case, 21 DR, D as in Delta, 1885.
See, and then today I was issued a warrant for
hold on, Mr. West, hold on. I do find that the plea is knowingly and voluntarily entered with the advice of good counsel. There is the proffer does support the allegations of the charge based upon his plea of no contest. I do find the defendant guilty on that offense. I will hear recommendations at this time from the parties concerning sentence. I'll start with the state, then Mr. Patterson, then Mr. West. I'll hear from you as well. Mr. Canfield.
Thank you. State is recommending a $100 fine, 8 months jail, suspended for 12 months, non-reporting probation. The state is also requesting the 5-day minimum, but it is my understanding that the time served on this case will satisfy that 5-day requirement.
Mr. Patterson.
Your Honor, we'd ask the court to adopt the recommendations. I have reviewed the records from the jail. He has been in jail on this case since January 22nd. We would ask the court to allow credit for time served as well as towards the mandatory 5 days.
This is a lot less.
Judge, again, in this case also, I'd ask the court to consider pursuant to case law waiving attorney fees. I can tell a court just from talking with my client that he is not somebody who has ability to make a wage, so that I think under the case law, he would be a prime candidate for the court to waive attorney fees.
All right. All right, Mr. West, is there any statement you'd like to make concerning your sentence?
Concerning my sentence, no. Now I am trying to gain understanding on see, today I was issued this morning with a failure to appear warrant on this same case, which we have court as of right now. Is this new charge of failure to appear going to weigh over, or is it going to dismiss?
Well, if it's in regard, if you were served paperwork on today's hearing.
No, it was today's case.
So this is for the city of Leon.
Yeah, that's where this was took place, was in the city of Leon.
Okay, this is the district court. This is not the city of Leon or municipal court.
Okay, well, that's only
what you're here for is what you're here for, and what we're dealing with is on when you were driving on June the 18th of 23 in Butler County. It doesn't say more specifically where in Butler County you were. Let me see.
Right, that I was in Leon, Kansas.
And Your Honor, the affidavit does say that the defendant was stopped in Augusta at 1/7.
All right. So it sounds like Mr. West,
all right.
Whatever paperwork you were served from there is something else. You'd need to address that with that judge. I'm not on that case.
All right. Now, here's my next question. Being that I was in custody, how do I get this failure to appear lifted?
Well, you probably need to take talk with the attorney that's going to represent you on that case.
Darren, will you please represent me on this case?
Judge, after this court hearing, can I have a breakout room with Mr. West, and I'll go over those things with him?
Yes, I'll permit that once we're done here. Okay. I am going to impose, Mr. West, anything more on this case as far before I pronounce sentence?
No, sir. That'd be it.
All right. I'm going to impose a $100 fine. I'm going to give a controlling sentence of 6 months in the county jail. I'm going to place him on reporting probation for a period of 12 months. I'm going to order that part of his probation that he follow the recommendations of his mental health providers and take his medication as prescribed. Mr. West, in looking at the docket notes from what happened on January the 22nd, it sounds like you're one of the people that benefit greatly from taking your medication. So I want
Correct
you,
medications, not just what they're doing for me right now, which is just substituting.
well, I want you to follow your doctor's advice and your therapist's advice in regards to the medications. Because if if you don't do that, then I think there's a pretty good chance you're going to keep coming back to court. And I don't think any of us want to see that happen. And probably the most you wouldn't want to.
Yes, sir.
Okay, so I'm going to place it, it'll be a standard probation otherwise. And the primary is not to violate the law. And I want you to follow your mental health and your physician's recommendations in regards to your medication. Okay.
Yes, sir.
And he will get jail credit for his time in jail here on this case. If this is the only hold on him, that he can be released. If there's another hold from another jurisdiction, I think Mr. Patterson's willing to talk with him about that. So I'll permit that that outbreak now. So that'll conclude Mr. West's case today. Mr. West, good luck to you.
Is the court waiving attorney fees, Your Honor?
I am.
Thank you.
Is the court ordering a supervision fee for the court services probation?
Yes, the $60 there.
Thank you.
Very well. This matter is adjourned. Next matter is State of Kansas versus Wesley Howard, case number 21 CR 510. Counsel, state their appearances, please.
Chair Regier, on behalf of the state.
Your Honor, Chris Pate, Wesley Howard, who appears by Zoom.
All right. And I believe you are Wesley Howard, correct?
Yes, Your Honor.
Very well. We are here on the stage motion for warrant to show cause or motion to revoke. Are there any agreements to be announced at this time?
Your Honor, I had some discussions with Ms. Norris right before court. I think we have an agreed resolution. Mr. Regier, or did Amber send you that information?
Your Honor, I believe I have been made aware of some prior communications between counsel for the defense and my office.
All right. Well, why don't you?
I'll go ahead and.
Yeah.
Mr. Howard is going to waive his right to hearing, stipulate that he is in violation of his probation. There's going to be a joint recommendation for a 2-day jail sanction, 6-month extension of probation with all previous conditions, and that Mr. Howard start the batterer's intervention that was recommended within 45 days of today. The only thing, I think Ms. Norris wanted him to start the jail today. Mr. Howard would be requesting that he be able to turn himself in next Friday. He lives by himself and he's self-employed, and he's also got, I think he said, 3 dogs in his home that he cares for, and just really wants some time to arrange for care of that and everything before he serves the time. But he is local. He lives in Augusta. He's self-employed and works in the area. So I don't think he's going anywhere, Your Honor.
Mr. Regier, is that your understanding of the agreement?
It is, Your Honor. If the defendant does fail to report, as suggested by Mr. Pate, the state would be requesting that the court enter orders in accordance with that, although I do not believe that was prior to the prior plea negotiations between counsel for the defense and my office.
And I want to be sure as to what the motion indicates, that the violations were failure to report as directed, failure to complete the batter intervention assessment or the BIP, and not making payments toward the case.
And Judge, he actually did complete the BIP assessment. He just didn't start the recommended treatment, and that's referenced in the request for revocation August 28th, where it says he completed it but didn't start the class, or completed the assessment, didn't start class.
Mr. Howard, have you heard what the attorneys have told me?
Yes, I have.
And looking at it appears that on August 17th of 22, you were found guilty of violation of a protective order and given a 6-month underlying jail sentence. Do you understand that while there's recommendations of the parties as to what your penalty should be for probation revocation, the court does have the authority to just order you serve the remainder of your sentence?
Yes, I do.
And you understand that you're entitled to a hearing where the state would have to show by preponderance of the evidence that you made these violations before the court could find that you violated?
Yes, I do.
And do you waive your right to that hearing?
I do.
Have you had ample time to discuss this with Mr. Pate?
Yes, I have.
Are you under the influence of any medication or intoxicants at this time?
No, Your Honor.
Has anybody forced or compelled you in some fashion to enter this plea?
No, Your Honor.
Very well. I do find that the defendant has stipulated to the violations with the advice of good counsel, and he made a knowing and voluntarily waiver of his right to a hearing, not been coerced or under the influence of any intoxicants or medications. And so I do find he's violated the terms of his probation. Is there any additional statements that counsel wish to make? Mr. Regier?
No, Your Honor.
Mr. Pate?
Your Honor, we just ask the court follow the agreement as set forth. I do believe it's a first PV. Mr. Howard is gainfully employed. I think he's actually on a job site as we speak on a under construction house. He did go get the evaluation. He needs some better follow through on that. I think he'll get it done this time if the court follows the agreement, gives him a chance.
All right. Seems to me like I was advised that the jail prefers that when people are reporting to serve a sentence, they wish to have that at 7 p.m. Is that accurate?
I'm not certain.
Security, Ms. Wheeler, perhaps you know.
That seems to be a standard time frame, Your Honor. But I've heard 6 p.m. too. I think 7 o'clock is preferred because I think they get the like shift change done by then.
And Your Honor, unfortunately, I do not have any personal knowledge as to that particular matter.
All right, Mr. Howard, what days do you generally take off?
Usually Sunday, but I can squeeze this in. I think I just need to find a place to keep my dogs. I think I can probably get in there before Friday. Is there a certain day?
What I'm contemplating is giving you a date and time that you have to report.
Okay.
Yeah.
I usually take off Saturday and sometimes Sunday.
All right. What you say you're self-employed. What is it that you do?
I build houses.
All right. This time of year, sometimes, or at least people I've known with that occupation kind of have some slow days. Is that
No, I'm actually really swamped. But any day that you said, I can make it happen.
All right, I am going to find that Mr. Howard is in violation of his probation, revoke that, and I'm going to reimpose him on reporting probation and extending this an additional 6 months. And let's see. So it would be, well, it'd be 6 months from today. A condition of that probation is that he is to report to the Butler County Jail to serve a 48-hour sanction on Thursday, February the 8th. Then he can be released on Saturday, February the 10th. And he is to report by 7 p.m. So he can be released at 7 p.m. Now that's going to be a condition of your probation. Mr. Howard, if you don't show up, that'll be a violation of your probation. My position on that, if I give people a break, such as what's been requested here, and if they don't show up to the jail, they're just telling me they're not going to comply with my orders, and they might as well just serve their time. So
yes, sir. Your Honor, to make sure I have this right, that is February 8th by 7 p.m., right?
Correct.
Okay, thank you.
Now, I may be assuming something that's not correct. That should get you out of a full 22 hours before the Super Bowl. So that may not have been, I was in my mind, if not yours. So I didn't want to interrupt.
It definitely wasn't, but thank you for that.
I didn't want to interrupt the jail.
My team didn't make it.
Well, it's a good thing you didn't share that with me before.
Well, you really don't want to know what my team is.
I don't. I'm just jesting with that. But that's when you need to report. You need to follow through with the recommendations. You need to get signed up for that course and do it directly. Any further delays, again, you know my position on it, that you need to get in there, and if they may require you to have a new evaluation or do that BIP again. Sometimes that's a timed situation, but then you need to be in that class and successfully complete it. All right?
Yes, Your Honor.
And any other terms that were previously on your probation are going to continue to be that probation. I don't know, Ms. Wheeler, do you have them sign a new contract, or just refresh the one with them?
Typically, we just go with the original, Your Honor,
Okay.
especially since nothing is really different other than the termination date. All previously ordered conditions are remaining. He just needs to get with the Batterer Intervention Program again and report to me again.
All right. Counsel, anything further?
Is there a certain date and time he needs to report, Ms. Wheeler, or should he just call your office to schedule that?
If he wants it, Wesley, if you'll just call me, if you still have my phone number, if not.
Yep, I have your number.
Okay, you have to report to me and you'll be reporting in person.
All righty.
All right.
Your Honor.
Yes.
Your Honor, is the court setting a specific time frame to begin the Batterers Intervention Program? I believe that was at least contemplated pursuant to plea negotiations.
I'm going to let Ms. Wheeler give her some discretion in regards to that, but Mr. Howard, you need to get that done by in the way that your court services officer is directing. All right.
Yes, Your Honor.
Okay.
To let court and counsel know that if Mr. Howard has to if he has to get another assessment and he has to do the batterer intervention program. It takes 6 months to complete. So I am going to be advising Wesley to get in a program immediately. Because he's not going to have enough time to complete it successfully within a 6 months extension. So he needs to get on it right now.
All right. Mr. Howard, I can tell you, and of course, everybody is different, but there's some people that I really thought were never going to change their ways, that batterers intervention program really seemed to help them. So, you know, put your best foot forward in that thing, and it may help you out a bunch. Okay?
Yes, sir.
All right. Anything further, counsel?
No, Your Honor. Thank you.
Very well. With that, we're adjourned.
Carly,
Well, that was the next one is giving me trouble here. Okay. All right. That was the Canfield Regeer block. Those guys, those defendants, I liked all the defendants. Like y'all noticed, a lot of the defendants were really kind of agreeable and understandable. There was some wacky stuff in there, of course, and you know, that definitely one that tugged at the empathy strings. But the one guy who wasn't doing himself any favors with the violations of probations, I thought it was real interesting. You don't see people show up to the Sally Port and get cuffed right there in the Sally Port a lot. I thought that was kind of unique. But yeah, I thought it was really nice to actually see a few defendants from the jail call who were really kind of, whether they looked it or not, really kind of on their P's and Q's. A few of them actually were able to probably get up from there and go through the checkout process right after their cases, which I thought was really cool. We got one set left, one set of cases, and this is going to be our Stevens set. Couple of different days that I chose this set from. Thank you. So this is kind of a compilation of a few different cases that just kind of caught my eye. Again, cutting room floor stuff that these are actually cases that I had edited and just for one reason or another neglected to get put into a video for, so I kind of squished them together and here we are. So let's watch this Judge Stevens set together. Just to let you know how long it is, it's 38 minutes and 39 seconds long. Any of you that are just now showing up, welcome. 20K celebration, yay. This is something that I never thought would ever happen. It's all because of all of you, and thank you everybody who subscribed over the last few months. Thank you for all of the congratulations and everything that are going on in the chat. I can't say thank you to everybody immediately, but just trust me, I do appreciate all of it. I appreciate everybody here. I can't say thank you enough. Well, I could say thank yous a lot, but I assure you would all get very, very bored of me just sitting here for the next 2 or 3 hours just saying thank you. Thank you. Oh, you like me. You really, really like me. Okay, we should really watch these court cases now. Talk to you guys after the court case. This time I'm actually muting the mic.
Carly Absher.
Sound like that.
Judge, we are waiting on test results from one of our experts in this case.
Last time we had this, we had last setting that it said that would be the absolute last announcement setting. We just go ahead and set the trial. Please, Judge.
All right, set for trial. What about
the safeguards we have as conditions of bond here?
You have
What
a
are they?
license. So you're not driving.
No, I don't.
She doesn't.
She's not allowed to drive.
It's one of her bond conditions. She's not. And her father is here. He drives her.
What about using drugs or alcohol? Do you use drugs or alcohol at all? So where do you live with your family,
Yes, sir, with my 2 kids and my dad.
ma'am?
With my 2 kids and my dad.
All right, well. Get a resetting, set it for trial.
Yes, sir.
And then just have a seat over there as well. Thank you.
That's all.
Before you leave. Robert Strahan.
We just put that on the file because she's outside.
Robert Strahan. This in the, is this the one that's getting disposed of today?
No, Shaw is. Shaw and French are going to get disposed of.
Yeah. I'm ready.
One of those, he says he didn't do it issues.
Twenty-two 40963 Robert Matthew Strahan. That's you?
Yes, sir.
Okay, it's an announcement. You're charged with the state jail felony of theft. And that is an announcement, right?
Yes, we just
Put on the
set
trial
up for
docket,
trial.
set for trial. Hey, Brian, she failed. She's got marijuana.
All right.
Now, this is the case. Ms. Asher, there was a fatality in your case, right?
Yes, sir.
And you're using drugs while on bond? Are you kidding me? You have no sense of the importance of sobriety after all of this? All right. Brian's not going to fix the mess. Come on up. What's her bond?
This Abshar's $30,000.
Okay. And you are Carly Absher in 22 40965. The court has ordered a urine test, which tested positive for THC tetrahydrocannabinol or marijuana. And one of the bond conditions is do not use drugs, and you're to submit to tests for alcohol and drugs at whim of the court. And under the okay, with what you're charged with this, which is intoxication manslaughter. And now testing for drugs. Here's what we're going to do. Your bond is revoked, and your bond is increased to it's doubled to $60,000. You must have a drug patch as a condition of bond. Do you have some kind of a device for alcohol?
She didn't drop the car. She didn't.
Well, of course, if you happen to drive a vehicle, you would have to have a an interlock device, but if she doesn't have a vehicle, then it's just easy for the court to say, do not operate a motor vehicle until further orders of the court. But the next time, it'll be $120,000 until it gets to a point where you're sitting in jail until all this. And Mr. Gertz just tried a case yesterday that had taken 3 years to finally get to court because of the backlog we have. And there are some people, just like you, who can't follow the bond conditions, and they're sitting in jail, which, I don't know if it was me, a day in jail, you can't have that back. And it's a day without freedom, and it could last a long time. But these are choices you make. And my advice is quit whining about it and show the character and strength that you should have to make the correct choices. Well, do it. Unless you're unable to make the right choice. So these are pretty simple, straightforward choices, especially in light of what's hanging over your head here for this charge. I can't imagine, fortunately, it doesn't happen a lot, but when it happens, we have to make something, it has to have a consequence that's adverse to your freedom. And are you employed somewhere? Yeah, which means to get out of jail, someone else is going to have to pay for it. It's going to cost thousands of dollars. That's what these bad choices, it costs you and or others as well. The thing, just can take one final step. You have to appreciate and understand that you're not on this planet alone. You got others, right? 7 billion others. We rely on each other for making good choices so that we can have a full life safely. And you got family and friends, I presume, who care for you very much. But they're not going to be able, they're not going to, by law, they can't sit in jail while you're making mistakes. You're a grown up and you have to make the wise choices. And you have to realize that bad choices have consequences. I think you're able to make the right choices. Well, why aren't you making them? Do it. See, there's some people in here who are hopeless. They don't have any hope. Like they're going to make every time they have a chance to make a bad choice, they're going to make a bad choice. I don't think that's you, but these are important mistakes that you have to fix. And you have to remember that your life touches other people's lives as well. Okay, well, fix that. Do it immediately and do much better. Especially you're capable of it. That's what's frustrating to me. It's like, but you've got to, like I and everybody, Mr. Gertz, your family, everyone, we all are held accountable to the choices we make. So make better choices than you've been making. All right, that's the orders of the court, and you're treated similar to everybody else who's in the same situation. Conformance. 23 CR 1661 is called, the state of Texas versus Jamal Petrie. That's you, sir? Sir. Present with Ms. Mantellini, your attorney and the state's attorney. Earlier, you pleaded guilty to aggravated assault with a deadly weapon. A pre-sentence report has been prepared in this case. If the parties had an opportunity to review it, and are there any corrections or changes to it? First of all, state.
Just I know what the argument is going to be today, so I do want to make some additions to this pre-sentence investigation report.
Okay, what about from the defense first?
That would be the only thing that I would, what he's bringing up. Nothing other than English.
We just saw this video not long ago.
Yes, sir. Yes, sir. So as it stands.
Who was the defendant there?
Pardon me?
Who was the other defendant? Were there any other defendants?
There's
involved
a
in this?
total of 8 defendants, Judge.
The last time. Okay.
Do you remember who the last person got sentenced in here? I know Beatty might have been the first
Yeah,
one.
the Cadrian Beaty was the first one to report sentence. But there are multiple defendants, and it's kind of difficult to keep them
I
all
believe they're-
straight.
And I believe they're listed in the recommendations of people for him to avoid. Number 16, that should be a pretty good list of them.
All right, so one of the things I wanted to highlight, Judge, is you just did sentence an individual that was on probation. He was the person that was carrying the AK-47 that Your Honor will recall from the video.
The defendant was named.
The co-defendant on that one.
Was that Foxhall?
That was Foxhall, Jalen Foxhall. And according to the page 3 of the report from Officer Visser, this individual, along with his brother, fled the scene in a black Hyundai 4-door sedan, along with that individual that was carrying the AK-47. That is one of the things I wanted to add to the report, because that detail is not in there. The report shows on page 2 that he was seen striking with a closed fist and carrying a handgun. I've confirmed that out of page 20 of Detective Armstrong's report. He was striking as well with a closed fist. I know the defense counsel has located a similar response out of Officer Visser's report, as well as Officer Armstrong, giving his description as well as the striking with a closed fist. So there may be an issue about whether or not he actually had a handgun. But the report that I found, according to the Detective Armstrong, he says that this individual was sitting in that same video carrying that same firearm. Didn't strike him with it, but he was seen.
In the report, the supplemental report that is attached to the indictment here in this court's file says this defendant, Jamal Petrie, could be seen in a video striking Jefferson with a closed fist. This person could also be seen carrying a handgun in the video. Does anybody disagree with that?
That is the state's position, Judge. And if I'm correct, Judge, that's coming off of page 20 of.
He was wearing all black, a gold necklace around his neck.
Yes, sir.
And this is true that how many individuals were striking the victim in this event? It says several, hitting him with closed fists, guns, and stomping him with their feet.
Your Honor, they either struck him with their feet. All individuals either struck the victim with a fist or with a gun. That is the state's position as to all 8 charged defendants. And those names are listed for you at the bottom of page 1 of the report, Judge.
All right. What else? State.
That's it as far as correction and highlighting, Judge.
Defense.
Nothing further.
Okay. The pre-sentence report states that the plea bargain is what's called 12 years imprisonment as a cap. The defendant is looking at no less than 2 nor more than 20 years confinement in prison. And this is aggravated assault with a deadly weapon, namely a firearm. So the only options are imprisonment no less than 2 nor more than 12 years confinement in prison, or deferred or unadjudicated probation.
Yes, sir.
Okay. Because the deadly weapon, affirmative finding there, that precludes regular probation as an option.
Yes, sir.
Oh, and then how long has the defendant been in custody now?
Oh, Judge.
While we're figuring that, go ahead, defense.
Right, Your Honor, first, let me start by saying that I've been in, what was the answer?
109.
We have been in this courtroom for quite a long time, whether I was practicing in front of you or on my own case or just present for other purposes. And I know the court's basic philosophy is, which is the correct one, is that we do make our own choices and we're responsible for our own deeds.
It sounds like a wise statement.
Yes, and very wise, but and so Mr. Petrie is standing before you, being responsible for his own deeds. I do want to just bring out a couple of things for the court to consider when making a decision on what to do in this case, though, never setting aside the basic concept that we are responsible for our own deeds and he is present before you for that purpose. Those videos that show the parking lot, there were really 2. I don't know which ones you've seen, but there's the right side where the fight ensues, and then there's the left side. But as a whole, just on the left side of the parking lot, and this is with your back to the store, looking across the parking lot toward the little areas where you pull in and fill up your gas. There were at least 27 cars on the left side of that parking lot.
27 vehicles?
Vehicles. Every one of the stalls or the little lanes that you get gas had a car in them, but nobody was getting gas. And then on the right side, you see all the other cars on that side during the entire time, which the videos are like 60 minutes. You could tell when they start, people were already there. I don't know for how long. People are coming in, riding around. People are wandering around. One lady's up on a hood, kind of like she's dancing. There are people laughing, people having a good time, but nonetheless, there are a lot of people on this parking lot of a gas station at 3:30 in the morning in the north end of Beaumont.
It's also a convenience store, isn't it? I mean,
Yes,
it's open for
Yes,
buying
Yes.
and selling items that
Yes.
people may need because other stores are closed.
Yes, but at the time, nobody was buying gas, and for 16 minutes, those cars never moved out of there. So it's also a gas station, but nobody who wanted gas was going to be able to pull in and get it because all the stalls were filled with empty cars. The bottom line that I'm trying to point out to you is that, there's a lot of things about this situation that are just disconcerting, aside from just the fight, the brawl, where all those people joined in and assaulted the man. There's something also to consider is, do we as a community, are we condoning store owners that just let people congregate in that? I'd say 27 cars on one side, maybe another 20 on the other. Plus, I don't know, 1 or 2 people in each car, and it's 3:30 in the morning. But the store owner doesn't call the police and say, look, I'm afraid this could get out of hand. Could you at least come make a presence? I'm surprised that the police hadn't ridden by on Concord Drive in between Delaware and I'd say Lucas and noticed that that's an awful lot of people just hanging around a parking lot doing nothing. And if there were people that went into the store to buy something, you didn't really see anybody leave, but you saw people circling around the area. And I would think that even if they didn't have the authority to say, it's getting a little bit too crowded here, this looks like anything could happen, I think you all should go home. Maybe even just parking on the parking lot among those 40 cars would be enough presence to deter any kind of event. But surprise, surprise, with that many people sitting around, standing around, walking around, half of them carrying, I don't know half, a handful of people apparently carrying guns, a disturbance. ensued. So, yes, when it wasn't even his fight to be involved in, he let himself jump up there and get him a punch in and back off. But he didn't start the fight. He didn't end the fight. He didn't apparently look like he was the one that caused all the people to be there. They were there all evening or from some period of time before 3 o'clock or 3:15 in the morning, just loitering around and congregating. So yes, our community doesn't want to stand for people who are going to want to do group assaults. But also, I think that taking into consideration the sum of the whole is really the sum of a lot of moving parts. That being, there was a situation that was being allowed there that it's not unlikely that this sort of thing could have broken out. And you see these kind of group fights. Kids have seen them in Westerns. You see them on the playground. You see them on the parking lot at a school. You see them on a hockey field, ice hockey, where people start getting into a fight that's not even their fight. So yes, although he should not have, he didn't start it, and he wasn't the last one to walk away either. He jumped in, got a punch in, not really knowing probably what the fight was about, and left. So all of that taken into consideration, plus the fact that he is accepting responsibility for his behavior. He doesn't have much of a criminal history, and not guilty, a dismissal, and a rejection of a case. In this case, and those were just misdemeanors. And then he has this pending. He's 23, I believe. Is that correct? So 22. And we would just ask the court to recognize that this is a person who shouldn't have let himself get involved in somebody else's fight. Did hit the man one time, did not throw the first punch, walked away as soon as he did that. You see him back out. And on the left side of the video, as soon as the fight goes, it looks like I don't know how many people scurrying away from it. This place was very crowded, and lucky not more people got hurt, or that guns weren't shot, because it was a volatile area, period. And we would ask the court to recognize that although he did involve himself, shouldn't have involved himself, he is sorry, from what he tells me, that he let himself get involved in that. And I would ask that you not sentence him to the maximum, the 12 years under this agreement, that you consider that this might be a person whose participation was not the most egregious, and would consider granting him probation. And maybe find himself figuring out how to direct his life to where he's not hanging out at a parking lot at 3:30 in the morning, because he's under the restrictions and the guidelines of this court and the probation office. And is that what you're asking the court to do, is to grant you probation? Yes, wrong. I really don't have anything further.
You have 3 children, correct?
Yes, sir.
Where were they when you were irresponsibly being involved in a felony offense late at night involving an aggravated assault? Why weren't you taking care of your family like responsible people do? I'm asking you a question. You didn't care?
Yes, sir.
Oh, no, I don't think you did. Or you'd have been with them. Nope. You'd rather be in a mob with responsibilities at home that you need to be taken care of. But you're out in the middle of the night causing a mess. But people, in all due respect to your attorney, who really doesn't have a lot to work with, but by what happened here, because this is terrible. And it's really, you can't blame it on the people who run the service station, because not calling out to the police to move people is not a crime. What you did was a crime. What others did was a crime. People don't want to go and shop at a place where there's mob behavior. That deters people can't, and I know the people who are running that service station want income and they don't want to run people off. But people who are there to get gasoline and other items because stores are closed in the middle of the night. So these are places that are open where they need to get something. They need milk or something in the middle of the night for their family. But not the way y'all act, not the way this group, the irresponsible people act. Who'd want to go there? It's not safe. Look what happened. That's the way folks are treating their own city. This is your home, isn't it?
Sir.
You've made it worse for everybody. And the others. It frightens people. They'd rather go somewhere else. Not this city anymore, the way you're acting. This is your town. You're supposed to treat it decently. Because you're supposed to be in it with everybody else. But you're working against what the leadership in the city and the county are trying to do. Make it a safe, responsible place to live and raise your children. The jobs are here. $40 jobs you can see anywhere you look, as long as you have an education and you're willing to work. But no, here we are at 2 and 3 in the morning, stirring up a mess. And I'm sure it gets passed on. Hey, don't go over there. Man, there are guns being used. People are getting beaten up. You got a crowd, you can't even get gas, and you got to move through a mob just to get inside to get some milk. Well, that's not what the Chamber of Commerce is trying to promote. You're working against progress and the others who are involved with this. It's a mess. Meanwhile, you got 3 kids. Mr. Role Model, you're a role model too. Don't expect your children to follow the rules. If you don't, you're going to be the most influential person to them. You know that though. You have parents, don't you?
Yes, sir.
And they influence you by the way they act, whether it's good or bad. It's natural. Where you have to act good. Not you pull everybody down who rely on you as an example. Stay.
Judge, this is not a punch as defense suggests. This is nothing but dangerous mob, violent criminal activity. I highlighted that this man chose to jump in the car with his brother and another individual with an AK-47 fleeing the scene after this. As your honor suggests, blaming the owner of this facility or the cops for not coming by, I find distasteful.
Well, she's trying to represent her client, and his actions make it hard to help.
All right. So what I'd like to do is highlight his conduct. His statement on page 2 is that I ended up at the wrong place at the wrong time. It was just supposed to be a fun night hanging out. Those were his comments. Page 5.
While the kids were at home.
Page 5 of your report, first paragraph says, his last offense, I'm reading the 3rd sentence, Judge, his last offense involved the defendant being caught again carrying a weapon by Bridge City Police Department only 2 days after this incident.
Is that true?
Yes, sir.
So what the, wait.
But
You
before
didn't
you
learn,
put too much more on the record, I don't think.
You
that
didn't
they were
learn a
able to
lesson
find
from what
anything
happened
about
here?
that, and I don't know if it's still pending or not, whether he had a weapon or not illegally.
hold on, everybody at once. What do you want to say?
Well, if he was charged with carrying in possession of a weapon, or it was something, an illegal act, since it's not prosecuted yet that we know of based upon the report, and there's no resolution there, I'd hate for him to make too many comments that could be used against him in a court of law in Orange County as far as that particular incident. So I don't
He has
know.
a fair opportunity to comment on what's in the pre-sentence report, and that's sitting in there,
Yes, sir, but it says unknown or something. There's
not found.
I read from the unobjected portion of paragraph 1 of page 5. To be in fairness, it goes on to say that this case has not been received by Orange County yet. But my argument, Judge, is that if somebody was in this scenario and they're just saying, hey, I just really didn't understand what was going on there, that person would not be caught 2 days later with a handgun.
Well,
That's,
I understand. You're going to go to something else because the way the presumption of innocence works.
yes, sir.
I mean, I'm
So-
kind of funny about that since I wrote an
Yes,
article on that. And
All right.
let's move
But
on. I'm not going to consider something that, and a charge is not a finding of guilt.
Yes,
And
sir.
if you, unless there's independent proof on something, the court's not going to consider that.
Yes, sir.
Go ahead.
Page 2, the detective reminds Your Honor in his statement under interested parties about the first individual that was sentenced in this course. That was the Cadrian Beatty. He received a 10-year sentence. He had the same deal that was offered here. He had the similar arguments about lack of criminal history and gave excuses for his conduct. And Your Honor justifiably sentenced him to 10 years, and he was responsible for striking the victim with a handgun. I would ask the court to assess a punishment along those lines. I'm going to stay consistent with every defendant that comes before you. They are all getting the same offer, which is a cap of 12 years. Each of them needs to be considered individually, but at no point in time will you hear me stand here and suggest that the appropriate sentence is some form of probation. My suggestion is 10 years.
Go ahead. The defendant, you can go forward, sir. Tell me what you think, Mr. Petrie.
Well,
Anything you want me to consider?
take full responsibility for my actions. I wasn't even supposed to be there.
What did you do? You're taking full responsibility. What did you do?
Struck the person one time, the victim one time
With a gun?
with my hand.
Why would you do that? Other people were getting the job done. If you wanted to assault the man, they were assaulting him. Why did you want to add to the ruckus when you got kids at home? Why would you do that? I mean, well, what is it that you hated that person so much that required that? What is it he did to you?
Nothing else.
Nothing. Go ahead. Anything else?
I just want to apologize on my behalf for what I did. I wasn't supposed to be there. I know I messed up. Regret it. Supposed to be home with my kids and my girlfriend. It's like that.
How were you raised? To be responsible?
Yes, sir.
But why? Why weren't you that night?
Being moving too fast.
Anything else you'd like to add from the defense?
No, just, when the first punch was thrown, I noticed that back behind another person, wasn't even part of the man with the red. One person hit somebody, like a second fight started at the same, right after it. And so, not that that's anything of any importance to anyone, except that
That's terrible.
it shows that it wasn't everybody just on one. It looked like people were gonna start fighting, like that.
Well, it's not humane. This isn't the way human beings are supposed to act. Especially adults who have responsibilities at home to take care of. You know that. But people see that video, and who'd want to come here? They're saying, what kind of an area is this where this kind of behavior occurs, where people take over businesses and don't, it's not a safe atmosphere for somebody to come out at night to get something in an emergency, since they're the only place open. It's not right, but we all know that it's happening too often. One after another. That's what we have a full load here. It's the 22nd largest county, but yet we have the 12th highest felony crime filing rate, according to the state statistics. That's not what people want. You're supposed to live safely. It's a community. That means that we're supposed to be in this together and we all move forward together. And there's no reason why you shouldn't be having one of those $40, $50 an hour jobs at the refineries instead of hanging around when you have family at home and fighting and making a mess. So we build hotels to bring people from out of town to work the jobs because you are frittering away your opportunity and others like this and just hanging around fighting when you need to be working and making a living, good money here. But it's like water through your fingers. But it's a choice we all make. I'm going to find again here that Mr. Petrie, you have pleaded guilty voluntarily to this aggravated assault with a deadly weapon, a second-degree felony. You were mentally competent to do so. You understand the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. And I'd like to also point out in this pre-sentence report that's part of the record, the investigating officials with Beaumont Police Department noted that the defendant's actions, along with the other co-defendants, were brutal in the way they assaulted and treated the victim as a human being. And I saw the video and I agree. I hereby find you guilty beyond a reasonable doubt of the second-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. You will be given credit for all time you have served. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this assault. Do you understand what has happened today, sir? Anything else? That is all. We are in recess in this case. We are in recess. We should reset.
Oh, that snuck up on me. Sorry. Oops. We are in recess. Look back over my shoulder here. You see that? I think he's ready for supper, guys. Well, it's been real. It's been a wacky last 6 months. I really appreciate all of the participation with the videos, all of the comments, all of the interaction. There's going to be lots more to go. As long as I can find court on YouTube to review and curate, I'm going to review and curate some court on YouTube. And this little guy over here and this little guy over here will be assisting with that process. So it's great to see you guys out for this live. I've just been ecstatic. I hope you have enjoyed the videos that I chose for the live stream. It's been fun chatting with you guys in the chat there and making our comments live together. And I'm going to keep saying and O and E. And you remember that lawyer that did that in Stevens? Yeah, every other and one. Anyway, guys, there is one more thing I have to do. I'm not sure how to do this properly. But here. We can't have an end to the stream without our theme music. So, I'm going to start the theme music, and I'm going to say good night. I love you all very much. Me and the cat both. Thank you all for all of your support over the last 6 months. And I am about to get attacked because I haven't fed him and he wants food. That happened. All right, guys, it's been a fun stream. I appreciate you all very, very much, and I can't read chat while I'm talking at the same time. I'm not that talented at this stuff. Guys, I'm going to be making some more videos. We'll see if I release any tomorrow or if we'll wait till Monday. It'll probably be Monday. I'm just going to be honest with you. Weekend's the weekend. Y'all have a great Saturday. Thank you for choosing to spend a little of your time on a Saturday afternoon with your Lone Wolf Ousel. I will see you next time. Next live stream is at 25,000, ladies and gentlemen. This is the long road to 100K. We'll get there eventually. Thank you for the 20K that we have now. We'll see you next time.